Hi, everyone. Welcome to panel number 13, which is Traveling Judges and Imperial Legacies on Domestic Courts. My name is Mitra Sharafi, and I'm a professor at the University of Wisconsin Law School. And I am delighted to be joining this panel as moderator. We have 5 speakers listed in the program, but what we're actually going to do is we're going to hear from Pamela Bookman, Alyssa King, Mathilde Cohen, and Anna Dzidzic. And then Erin Delaney is actually going to come in at the end as a discussant. So we will begin with Pamela Bookman of Fordham University.
Thank you so much. I'm so pleased to be here with this terrific panel. I'm here to present a project that I've been working on with Alyssa King. So I'm going to speak for a little bit and then she will take over. And this is a great audience because we're in the context already of the idea that judges on domestic courts, who are often thought of as domestic actors, are actually foreign actors, right? So the figure of traveling judges complicates our traditional concept of judges on domestic courts as domestic actors. So we define traveling judges as judges from one jurisdiction who sit on a domestic court in another jurisdiction. And I think each of the panelists will speak about this phenomenon in different contexts. Alyssa and I are interested in when this happens on courts that focus on international commercial disputes. So something kind of like international commercial arbitration, but it's a domestic court adjudicating these kinds of disputes. And we found a number of jurisdictions that invite foreign or outsider judges to come to their jurisdictions, usually temporarily, to sit and hear these cross-border commercial disputes. In order to identify which courts we were talking about, like which courts do this, we first had to identify a set of courts that work on international commercial disputes. So you have, for example, the New York Commercial Division, or London has a commercial list. All of them, those are domestic courts. They will hear domestic cases, but they're magnets for cross-border commercial disputes. Neither of them, however, have traveling judges. Those both, New York judges sit on New York courts, London judges sit on London courts. And so we identified that there's an organization called SIFOC, which is the Standing International Forum of Commercial Courts. So this is a self-identification of a court, that we are a court that wants to join this international forum of commercial courts. And of the courts in that forum, about 10 of them, 10 different jurisdictions, have traveling judges. So they have judges from other jurisdictions whom they've invited to come and sit on their courts. And as you see from this list, they're really all different kinds of courts, and they're all different, and they're from many different regions of the world that fit this description. But they're all, just to want to be clear, they're all domestic courts. And in this context, that's pretty clear because all of us are really talking about domestic courts. But sometimes when you hear international commercial disputes, you think we're talking about an international court. These are all, even despite their names, even sometimes they have the word international in them, they're all domestic courts. And some of them are general purpose courts in small jurisdictions that are within or formerly within the British Empire, that they have non-local judges. So that includes the Caribbean courts within the UK, like the Cayman Islands or Bermuda, or the Hong Kong Court of Final Appeal. It also encompasses, there's a recent spate of courts that self-identify as international commercial courts. These are courts in jurisdictions like Singapore, Dubai, and Kazakhstan, where local authorities have set up a common law court, sometimes within a special economic zone that has identified its own domestic law just for that special economic zone as a common law jurisdiction. And they've set up courts to handle international commercial disputes. And they usually sometimes have some local judges that sit on this court. For example, the Singapore and Dubai International Financial Center courts have some local judges on these courts, but also invite a number of international judges to sit on these courts. And so our broad project studies these judges. Who are they? how do they approach judging? Why are they there? What do they offer to the host state? How do they change the nature of judging, the nature of the development of international commercial law? These are our big picture questions. And we're really interested in how it intersects and dovetails with the research of the scholars on this panel, who are also on this panel, about traveling judges in other contexts, in constitutional contexts, for example. But we think that this presents some overlapping, but also some distinct issues. And so that's sort of an overview of the broad project that we're working on, and it probably will lead to, we're hoping it will lead to several papers. But Alyssa is now going to talk about the sort of the next steps in the analysis that we're working on.
Sure. Yes. Or as Pam said, our current paper is concerned with identifying who these traveling judges are. And one of the things that you can see from this list is you really can't escape the colonial history. All of these courts, except for the one in Astana, are in jurisdictions that had some relationship with the British Empire. Either they were crown colonies, or in the case of the courts in the Middle East, these were protectorates. And so you have sort of two colonial court models there. You have the model of actual colonial courts, and we'll hear more about that in relation to France from Mathilde, where you had judges traveling within the British Empire. Primarily, it was barristers from the UK and also from the Dominion colonies. People who weren't doing well at home would join the colonial legal service and go be judges in other jurisdictions. And then they would circulate within the empire based on the needs of the legal service. You also had consular courts. So that was a model in the trucial states in the Middle East, the states that are now the UAE and Qatar, where it wasn't an establishment of a common law system for the entire jurisdiction, but rather there were consular courts that dealt with British property. And so they were commercially oriented. They kind of grew up around the discovery of oil. And you had a sort of model of a more limited courts with special mandates. And both of those models, of course, come into today because we have judges who are traveling within a common law world, and we have the idea of sort of limited jurisdiction, special international commercial courts. So what do we find when we try to figure out who these judges are? And this is another portion of why the empire matters so much. About half of them are English, over half. So this is a graph we have of the home jurisdiction. And so what we defined as home jurisdiction for the judges was based on where they practiced. So not so much based on citizenship, because in the case of some of these jurisdictions, right, that doesn't tell you that much if we're talking about Hong Kong or we're talking about British overseas territories, but where did they practice? Where were they appointed to government? Maybe where they had appointments as a domestic judge originally. So most of the traveling judges in our study had appointments on their home jurisdiction courts first. And in some cases, home jurisdiction was a little bit more difficult to figure out. We can talk more in the Q&A about how we decided where there were people who had practiced in multiple jurisdictions. But you can see kind of here, a sort of very clear orientation still towards English law. English law is still in demand and English judges are in demand, but at the same time, right, they're only about 51%. And when you look at the rest of the jurisdictions represented, it's really broad in terms of region. It's not simply the former Dominion colonies, although Australia, has a decent chunk of that. It's nowhere near what we see for England and Wales. And we don't see, for example, Canada having a lot of this judicial business. So there's somewhat of a shift there. The other thing that we looked at in terms of looking at who they are was and what their legal culture is where they got their legal education. So the United Kingdom pulls even further ahead. And in some ways that was no surprise, because the law that a lot of these courts are applying is very close to English law. In some cases, they directly transposed things like the CPR, the Civil Procedure Rules, from England and Wales. In other cases where you have former British colonies, there was a lot of English commercial law received during the colonial period, which is not that far away or is ongoing if we're talking about overseas territories, right? Or you have an explicit choice to bring in English style commercial law later or into new contexts. So it's not a surprise that judges with a legal education in the UK who'd be able to interpret English law are in demand here. And then we have really a focus on common law legal education overall. So there's, here, let me just stop share. There we go. So that was interesting that English law continued to be quite dominant, but at the same time, we also see judges who have very different profile than the colonial judges did. So these are elites. And for the most part, they are judges who had significant judicial experience at home, sometimes also abroad. So they'd already been traveling judges on other courts. They are also judges who typically are in demand as arbitrators. So about half of them sit as international commercial arbitrators at the same time. And this is unlike the traveling judges of the colonial period, who were usually people who didn't make it in London. Right, so we're moving from having sort of people who didn't make it in practice to suddenly, members of the UK Supreme Court who are traveling to sit on foreign courts. So there is a significant shift in that way. Of course, if we're talking about the elite English bar and something that's dominated by the elite English bar, you get the kind of demographics that you get with the elite English bar, which is primarily white and male. So some things perhaps change a little bit less. And one of the things that we want to look at more closely now as we're trying to wrap up some of this research is what they do. So we know, for example, that they're arbitrators, that they're not sitting full time for the most part. For most of these courts, there's no residency requirement. There's no requirement about how much they sit per year. And in many cases, they're flying in maybe once or twice per year. What we're doing right now is we're trying to count up how many cases in each jurisdiction the judges actually made merits decisions. So either a final judgment at the trial level, or they participated in a merits decision on appeal, not just a decision of whether to grant the appeal or a decision on costs. And in a lot of jurisdictions, it's like once or twice per year, if that. In Hong Kong, we found that some CFA judges have not actually participated in any merits decisions during their entire 3-year term on the CFA. So that's something that we'd like to get more information on, as well as how they are participating in the creation potentially of an internationalized commercial law by looking at their citations. Are they citing other courts that they've sat on? Are they citing themselves from other jurisdictions? One of the things that the working conditions issue brings up is that these judges resemble arbitrators in a lot of ways, right? So again, they're elite experts. They're flying in rather than sitting full time. They're kind of like arbitrators on an arbitration provider list, right? You have a nice list of arbitrators, but how often that person actually sits as an arbitrator under those rules may be relatively seldom. And I think Pam wanted to talk about also some of the implications for how we think about sovereignty when you are explicitly inviting in a foreign judge.
How are we doing on time? I can sort of save that for later.
Together, you've got about 12 minutes more.
Oh, okay. Well, I mean, I'll say a few words on that, and then I'll wrap up. I mean, the short version is that I find it, you find even in the writings of some of these judges who have started writing short articles about, you know, the advent of international commercial courts and the start of this phenomenon. And I was recently speaking to someone just today who said, like, there are a lot of other jurisdictions that are thinking about doing some version of this in different ways, and including the inviting of foreign judges sometimes. And on the one hand, they're domestic courts, they're arms of the state, and on the other hand, the whole point of inviting these foreign judges is that they're separate from the state, right? That the signal that having these foreign judges on the court sends is one that's sort of independent, really, from the state. And it's a fascinating sort of puzzle to get your head around. And I'm really curious to engage with Anna, for example, in her work on how that sort of plays out in other contexts. But I think I'm going to leave that there, sort of float that idea, and I'm really looking forward to this conversation.
Great, thank you both. Next, we are going to hear from Mathilde Cohen.
Sorry. So
Mitra, the